Okay, so let's talk about how judges get their jobs. So we're going to be talking about judicial appointments. Federal judges are appointed by the president, and then they're subject to Senate confirmation. So let's go back and forth between these two because there's several elements for each one. Typically, the president does not take a personal role in selecting judges to the district court level. That's usually left to some staffer or some official inside the Justice Department. They'll come up with a short list, and then the president will make the nomination. Supreme Court judges, the president takes a much more personal interest in and is more likely to be involved actively in the process of selecting Supreme Court nominees. Whenever the president makes an appointment, that nomination is sent to the Senate, which has to confirm the appointment. According to the U.S. Constitution, these judges are appointed with the advice and consent of the Senate. Although the recent practice has been basically the Senate gets to say yes or no, it typically is not that involved in terms of making the actual nomination, other than district court. It's primarily the role of the president, who then sends it to the Senate. Once the Senate gets the nomination is submitted to the Senate Judiciary Committee, and the Judiciary Committee will begin to schedule hearings where they'll listen to interested parties and determine whether that person should be confirmed or not. Then the recommendation of the Judiciary Committee is sent to the full Senate, and the full Senate will then vote to confirm or reject. Up until the presidency of Ronald Reagan, the primary reason a judge or justice might be rejected by the Senate would have been perception of lack of qualifications, not enough time on the bench, some sort of skeleton in the past, what have you. Although beginning with Reagan, we see a growing desire on the part of the Senate to examine the nominees' ideology and party identification, and to make a decision based in part on that. This is most evident with the rejection by the Senate of the nomination of Robert Bork. This leads to the term called borking, where the Senate would reject someone based upon their ideology. Another factor that concerning judicial positions is the concept of senatorial courtesy. District court judges officially are appointed by the president and confirmed by the Senate, but in reality they are appointed by the senators from that state. I'll say that one more time. Federal district court judges are officially appointed by the president and confirmed by the U.S. Senate, but in reality federal district court judges are appointed by the U.S. senators from that state. The way the system works is this. If the president were to send someone to the Senate for a district court judge that the senators from that state found objectionable, because of the concept of reciprocity, we would expect that the entire Senate would vote to reject them. Knowing this, presidents basically consult with the senators from that state, particularly those of their party, and essentially ask for, tell me who you want. And then those U.S. senators tell the president, this is who I would like to see, and that's who the president appoints. So senatorial courtesy, again, the ability of senators from a given state, U.S. senators from a given state, to unofficially appoint federal district court judges. Different types of jurisdiction that courts have. Number one, original. A court that has original jurisdiction has the authority to hear the case in the first instance. That is to say, the case will start there. This would primarily be trial courts. Trial courts are courts of original jurisdiction. That's where the case starts. They will sift through the facts, make a decision of fact, and then will interpret and apply the law. Then there are appellate courts. These courts hear cases on appeal. If a court has appellate jurisdiction, they have the authority to hear the case on appeal. Exclusive jurisdiction. A court that has exclusive jurisdiction has the authority to hear a case to the exclusion of all other courts. It would be the only court that the case could be heard in, either starting there or on appeal. Concurrent jurisdiction is where a court could hear a case, but also another court could hear the same case. So the case could be filed in either Court A or Court B. Supreme Court. The United States Supreme Court has 9 justices. The reason why it has 9 is simply because Congress said so. The size of the U.S. Supreme Court is not specified in the U.S. Constitution. Rather, it is set by the Congress. Originally, as a bit of trivia, the first Supreme Court had 6 justices, and each justice, in addition to sitting on the Supreme Court, also wrote a circuit and acted as an appellate judge. But over time, the number of Supreme Court justices has been expanded to 9. The jurisdiction of the U.S. Supreme Court is as follows. The U.S. Supreme Court has both original and appellate, exclusive and concurrent jurisdictions. The original jurisdiction of the Supreme Court would be all cases involving diplomats and cases where a state is a party. So the state of Oklahoma or the state of California would be a party to a case, a federal case. The Supreme Court would be the court where the case would start. Again, the original jurisdiction of the U.S. Supreme Court is cases involving diplomats and cases, federal cases, where a state is a party to a case. The appellate jurisdiction of the U.S. Supreme Court, subject to congressional review, is all other cases. Assuming Congress has not passed a law to the contrary, the U.S. Supreme Court has appellate jurisdiction over all other federal cases. Exclusive jurisdiction. The exclusive jurisdiction of the Supreme Court would be cases where a state is a party. In cases where a state is a party, no other court in the federal system can hear that case. Concurrent jurisdiction of the U.S. Supreme Court would be cases involving diplomats. Because the U.S. Supreme Court has original jurisdiction, it would start in the U.S. Supreme Court, but the Congress also has the authority to vest that jurisdiction in district court, and it has chosen to do so. So in cases involving diplomats, the case could be filed either first in the Supreme Court or in the U.S. District Court. So in that instance, cases involving diplomats would be concurrent between the Supreme Court and a district court. The U.S. Supreme Court typically does not have to hear a case on appeal. So the way you would get your case heard is you would file a petition for a writ of certiorari, commonly referred to as cert. And what you're essentially doing then is you're asking the court for permission to hear your appeal. The court grants cert by a vote of 4 justices. This is commonly referred to as the rule of 4. Again, you have no right to have your case heard by the Supreme Court. You, in essence, ask permission by filing a petition for a writ of certiorari. If granted, the court will then issue the writ, which will order the lower court to send up records for review. To grant a writ of certiorari, or cert, requires the affirmative vote of 4 justices. The U.S. Supreme Court's caseload is relatively small compared to other courts. It typically will hear in the neighborhood of around 100 cases a year. Approximately 20 years ago was around 120. Now it's around 100 to less than 100. So this caseload of the U.S. Supreme Court continues to shrink. What type of cases will get cert? Primarily, it's going to be cases where you have 2 or more courts of appeals disagreeing as to the meaning of the same federal law. Okay, so a case has to be filed in a district court. If you don't like the decision there, it can go to a court of appeals. Well, imagine a very similar case filed in another judicial circuit and a district court and goes to a court of appeals. So you could have 2 courts of appeals deciding that the same federal law means something different. That is the type of case the U.S. Supreme Court is most likely to accept for review, because the reason is that the U.S. Supreme Court wants to ensure that that federal law is consistently interpreted throughout the country. Other instances where the Supreme Court might grant cert would be some issue of profound national importance. That's kind of one of those, you just kind of know it when you see it. Once the Supreme Court has accepted the case for review, they schedule a time for oral argument. During this time period, the attorneys will come before the court and argue. Each side gets 30 minutes. In reality, it's not much of an argument. It's more like a question and answer session. And this really works to the attorney's advantage. Prior to doing the oral argument, they have sent up very detailed legal briefs that outline their arguments. So it's really a good time to answer any questions or concerns that the justices have. After oral arguments are concluded, The court begins to go into weekly conferences. They have weekly conferences that are held in secret, and this is where they discuss the cases and then vote upon them and assign the writing of the opinions. Parties that are concerned about the decision that might be made in a Supreme Court case can file an amicus brief, and we did talk about these whenever we considered special interest groups. For a party to be heard in court, they have to have standing. They have to be directly affected by the outcome of the case, not indirectly affected or concerned about the precedent that it might create. They have to have standing, directly affected by the outcome of the case. But because the United States is a common law legal system, these precedents do have an impact beyond the individual litigants that are involved in the case. So it's quite common that special interest groups will file these amicus briefs in an attempt to influence the Supreme Court's decision-making process. There's some questions as to whether these have much impact. Amicus briefs that are filed by the Solicitor General of the United States that give the opinion of the United States if it is not a party to a case are typically read by the justices and given some consideration, but the general consensus is that amicus briefs, other than those issued by the Solicitor General, don't get a lot of weight by the court.